Have you ever wondered if your carefully structured LLC truly provides the impenetrable shield you think it does? Or perhaps, like many high net worth individuals, you've heard whispers about offshore strategies but dismissed them as overly complex or even illicit. Today, we're peeling back the layers to reveal a stark truth that many financial and legal advisors simply won't tell you: why LLCs in many critical scenarios don't protect your assets, and why offshore structures, when implemented correctly, offer a level of security that domestic options simply can't match. Hi, I'm the business guy. I'm the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. I've been in the asset protection field for 34 years, and for nearly 30 of these, I've been setting up Cook Islands trusts. In fact, our firm has established more Cook Islands trusts than any firm in the world. And today, we're diving deep into why LLCs often fail to protect your assets and how going offshore can really be a game changer that you need. If you're serious about safeguarding your wealth, hit that subscribe button if you haven't, so you don't miss out on more insider strategies like this. Let's get into it. First off, let's level set on what an LLC really is. A limited liability company, or LLC, is a popular business structure that blends the flexibility of a partnership with the liability protection of a corporation. In fact, I started setting up LLCs for clients in 1994, and the LLC is designed to shield your personal assets from business debts and lawsuits. So, sounds great on paper, right? And for everyday operations, it often works just fine. When it comes to hardcore asset protection, think aggressive creditors, massive lawsuits, or even divorce proceedings, LLCs have some serious cracks. So why is that? Because the U.S. courts have broad powers to pierce the corporate veil, and that's legal jargon for ignoring the LLC's separation and going after your personal stuff if they think that you've blurred the lines between business and personal affairs. So maybe you've used the company card for a family vacation, or you didn't keep meticulous records. Boom, veil pierced. According to a 2023 study by the U.S. Chamber of Commerce Institute for Legal Reform, the tort system cost small businesses $160 billion in liability expenses. And get this, recent data shows that 9 out of 10 businesses face a lawsuit at some point in their lifespan, with about 45% currently entangled in active litigation. So that's not just statistics, that's real people watching their hard-earned wealth evaporate. Here's the critical distinction that often gets overlooked, and it's where the illusion begins to crumble. LLCs offer very limited outside liability protection. So what does outside liability mean? Let's say this is your LLC here. It kind of acts like a brick wall. Here's you and your personal life over here, and here's your business life. There's a factory with a smokestack. Inside liability is the liability that happens here, say when your business gets sued. An LLC works pretty well to protect your personal assets against that business liability in most cases. But an outside lawsuit is when the lawsuit happens from outside the business. Let's say that you rear end somebody in your car, you're sued personally. How does that LLC shield your business assets? Your business assets may be your business. You may have another LLC that holds a rental property, an additional LLC that owns another rental property, maybe an LLC that owns a stock brokerage account, and so on. How does the LLC shield the assets that are inside the LLC from a lawsuit coming at you personally? So that's what we're asking about. Think a car accident where you're at fault, a personal guarantee on a loan, and that car accident, for example, is they sue you for more than your insurance covers. It could be a malpractice claim if you're a doctor or other professional, a divorce, or even a judgment from a personal dispute. In these scenarios, the lawsuit is against you personally and not your business. And when you, the individual, own membership interest in an LLC, those interests, which represent your ownership stake and the value of the assets held within the LLC, can become a target, and they often do. Most states have what is called a charging order provision for LLCs, and this provision is designed to protect the other members of a multi-member LLC from having a co-owner's creditor become a de facto partner of their LLC. So the charging order essentially gives the creditor the right to receive any distributions of that LLC that would potentially go to you. So sounds good, right? It means the creditor can't seize the LLC LLC itself, or take over its management, or force a sale of its assets. They can only wait until distributions come out of the LLC that would go to you. However, here's the catch, and it's a big one. The LLC's operating agreement can simply state that no distributions will be made, or the other members can vote against making distributions to you. So what does the creditor get? They get to wait and wait and wait some more, potentially indefinitely, for distributions that may never come. And they're left with what's known as an economic interest but no control, and this is often touted as the ultimate protection that an LLC offers. So take John, a hypothetical but all too real entrepreneur based on cases that I've seen over my 34 years in the business. John ran a construction firm through an LLC, and the subcontractor botched a job, leading to a $2 million lawsuit. Now, John thought his LLC would protect his personal home and investments, but the court found that he had commingled funds. Naturally, your opponent, when they sue you, they're going to look for all kinds of ways and theories of legal liability to try to get the money out of you, right? So they're going to make up stuff. You're going to find anything that you did wrong, but the court found that he commingled the funds, paying his personal bills from his business account in this case, and pierced the veil, and he lost everything. Subtle humor alert. It's like building a fortress with a welcome mat for invaders. LLCs provide limited liability, sure, but the term limited is the key word here. It's not bulletproof. Its protection is limited. The cliffhanger here is, what if I told you there's a structure where courts just can't waltz in and seize your assets? They can't jump in and seize everything that you own. So stick around, because we'll reveal how offshore options flip the script. Now, before we go further, let's go ahead and bust some myths that keep people clinging to LLCs like a life raft in shark-infested waters. Myth number one, my LLC protects all my assets automatically. Nope. If you have a single member LLC, you're especially vulnerable. In states like Florida, following the Olmstead versus FTC case in 2010, courts ruled that creditors can seize the entire LLC interest, not just get a charging order, which is basically a lien on distributions. Myth number two, multiple LLCs can mean ironclad protection. Now sure, layering LLCs for different properties or businesses might help isolate risks, like putting eggs in separate baskets. But if a lawsuit targets you personally, say from a car accident unrelated to business where they sue for more than your insurance covers, which is so common, those LLCs won't shield squat. Personal guarantees on loans, common banking, and they bypass LLC protection entirely, making you personally liable. Myth number three, LLCs are cheap and easy, so why complicate things? Sure, they're affordable to set up, often under $1,000, but the hidden costs of failure? Priceless in the worst way. Recent reports indicate that approximately 66 million cases are handled in the U.S. state courts each year, and in a litigious society where tort costs are ballooning to over $529 billion as of 2022 and projected to rise further, relying solely on domestic tools is like playing Russian roulette with your net worth and the increasing theories of legal liability that make you more and more vulnerable. Here's some actionable advice. If you're using LLCs, at least follow the formalities religiously. Separate bank accounts, annual meetings, detailed records, but don't stop there. As we'll see, true protection often requires looking beyond U.S. borders. Now, common reasons for piercing the veil include commingling of funds, that is treating the LLC's bank account as your personal piggy bank, undercapitalization, forming an LLC with insufficient capital, failure to observe formalities, that is not holding meetings or keeping records. Now sure, there are fewer formalities than corporations have, but that doesn't mean there are none or that every judge will rule the same way. Fraudulent transfers, that is moving assets after a lawsuit looms, even if the veil isn't pierced, domestic courts have broad equitable powers to assist creditors, especially with single member LLCs in most states. Now here's a cliffhanger. While a charging order can be a deterrent in some states, it's not foolproof, and in many jurisdictions it's far weaker than you might imagine. In fact, some states allow for more aggressive creditor remedies, even permitting foreclosure on the LLC interest. In fact, we'll delve deeper into recent cases where that happened coming up. To drive this home, let's look at some real-world cases, and these aren't hypothetical. examples there pulled from the court records, and they illustrate how LLCs crumble under pressure. Case 1, the Olmstead debacle. Al Olmstead, a Florida resident, owned a single-member LLC holding millions in assets. Now, the FTC came after him for fraud, and the Florida Supreme Court ruled that a charging order wasn't the exclusive remedy. Creditors could foreclose on the LLC, liquidate assets, and walk away with everything. And this sent shockwaves, prompting some states to revise laws, but not all, leaving single-member LLCs exposed. Case number 2. In a recent 2024 Texas case involving a business owner who paid personal expenses from the company's LLC account, when a tenant sued over injuries, the court pierced right through the veil, holding the owners personally liable for $1.5 million. The LLC, useless as a chocolate teapot. Case number 3. Consider Ean versus Graham, a case from late 2024, where Nevada courts examined alter ego liability for an LLC. Now, also, the veil wasn't pierced in this instance due to proper formalities. It highlighted the vulnerabilities had the owner commingled funds. The outcome would have been different, would have been flipped. In another 2024 New York arbitration, the Lockett case also saw corporate veil piercing upheld, allowing creditors to pursue assets despite the LLC structure. Now, according to legal reviews, courts pierced veils in about 50% of cases where it's attempted, often due to failure in following corporate formalities. So the lesson here is LLCs are a good start for basic liability, but they're no match for determined litigants. So imagine Dr. Emily, a successful surgeon who owns several rental properties through individual LLCs. Now, she's meticulous about her business affairs, and one day, while driving home, she's involved in a severe car accident, a purely personal incident, and the other driver sues Dr. Emily for millions beyond her insurance coverage. Now, this isn't against her practice or properties, it's against her personally. Now, her LLC membership interest became target via the charging orders. If single member, courts might allow foreclosure. So poor drafting or sole ownership exposed. So this is where the domestic LLC illusion truly shatters. But here's where it gets really exciting. What if I told you could place your assets in a jurisdiction that laughs off U.S. judgments instead of caving into them? So don't go anywhere. We're about to uncover the offshore advantage. All right, let's shift gears to the powerhouse of asset protection, Offshore Trusts, specifically in the Cook Islands, which is in the South Pacific, and Belize. As the CEO of the Lawyers Limited law firm and asset protection planners, I've been setting up Cook Islands trusts for nearly 30 years, and our firm has established more of them than anybody in the world. And that's not hype. It's a track record built on helping high net worth individuals shield their wealth ethically and effectively. So why the Cook Islands? This South Pacific nation has crafted laws that prioritize asset protection like no other. Belize, down in Central America, by the way, also has great laws and is often our first choice if you're already in a lawsuit. So unlike U.S. structures, a Cook Islands trust doesn't recognize foreign judgments, meaning a U.S. court ruling against you. It holds zero weight there. Creditors must refile their case in the Cook Islands, or Belize for that matter, prove fraudulent transfer beyond a reasonable doubt, which is a sky-high bar, which we've never seen anybody actually be able to accomplish, and do it within a 1 to 2 year statute of limitations period for most claims. Oh, and they have to post a bond up front or pay the attorney up front, and that could be $100,000 just to start. So no contingency fees either. Attorneys need upfront payment, deterring many. So this isn't about hiding money. It's about a legal fortification. It's putting your seatbelt on. Offshore trusts protect against frivolous lawsuits, divorce, or business failures in a way that LLCs simply can't. And for those wondering about taxes, properly structured, they're tax neutral. You still report and pay the U.S. taxes on income via the FBAR, the Form 3520, the Form 3520A. So it's full disclosure of the IRS. It's not a tax thing. It's protection, not evasion. So statistics show global offshore wealth strategies are booming, with high net worth individuals holding trillions abroad, and reports estimating global financial wealth at $305 trillion last year. Now, the Cook Islands itself has a long-standing history as a pioneer in asset protection. Their International Trust Act of 1984 was designed to create a secure jurisdiction refined over many many decades. So when you choose it, you're tapping into a proven precedent. So how does it all function? At its core, a Cook Islands trust is an irrevocable trust where you transfer assets to a trustee in the Cook Islands. But here's the beauty. You retain significant control without owning the assets legally, so creditors can't touch them. And the irrevocable thing? Well, you can ask the trustee to make certain changes, add or take away beneficiaries, and do certain changes. So that way, the courts can't control you and force you to change the beneficiary to your opponent. That's why it's irrevocable. And we structure it with a Cook Islands LLC inside of the trust, okay? Now, the client, you, serves as the initial manager of that LLC, handling the day-to-day decisions like investments or distributions. You're the signatory on the bank account. It's like driving a car without holding the title. So assets go into the LLC, which is owned by your trust, and everything hums along normally until trouble hits. When a lawsuit strikes, duress event, we call it, our licensed bonded trustee law firm steps in. They take over management of the LLC temporarily, protecting the assets from court orders, forcing you to repatriate funds. So you don't have to bring the funds back, and they step in and they run interference because U.S. courts don't have jurisdiction, and U.S. judges can't compel the foreign trustee company to comply as they're outside of that judge's jurisdiction. So once the threat passes, the control reverts back to you. So it's seamless, proactive protection. This includes a flee clause. If a U.S. court compels you, the local trustee resigns, and we can shift the trust to another jurisdiction like Nevis or Belize. So we can change trust jurisdictions from one country to another if we want to. So it has a great flexibility. Now compare that to an LLC, no such firewall. It's always under the U.S. judge's jurisdiction. Okay, now what about the cost? The setup runs between $20,000 to $50,000 usually, depending on how much real estate and other assets you have and whether or not you're already in a lawsuit. But it's a one-time investment with a small annual renewal for peace of mind. So if you have over $500,000 to protect, you can visit us at assetprotectionplanners.com for a lot more free information, or if you're serious and not just curious, you can get a free consultation to see if this fits your particular situation. Okay, cliffhanger time. But does this really work in the real world? We've got success stories that'll really blow your mind coming up next. So diving deeper, the benefits of a Cook Islands trust eclipse LLCs on every front. First, asset versatility. It safeguards everything from real estate, which includes liens and equity stripping, other strategies with real estate, stocks, cash, even yachts or art collections worldwide for that matter. LLCs, mostly business specific, owning businesses. Second, the high burden of proof. Creditors must prove fraudulent transfer beyond a reasonable doubt, not the civil preponderance of the evidence standard in U.S. courts. So that's like upgrading from a bike lock to a bank vault. Third, no veil to pierce. Since you don't own the assets, they're in the trust, they're owned by the trust, there's no personal liability bridge. In contrast, LLCs fail when personal actions bleed into business. Statistically, offshore trusts like these have withstood attacks in over 99% of the cases based on jurisdictional reviews. Why? Jurisdictions like the Cook Islands aren't bound by U.S. reciprocity agreement. In fact, in our case, 100% of the time, I've never seen one of our trust pierce. And like I say, we've set up more of them than anybody in the world. So it's a legal moat. Here's a little humor break. Think of LLCs as coach class, basic but bumpy, offshore, first class with champagne and legal armor. Beyond legalities, there's deterrence. Plaintiffs see the hassle, relitigating abroad, no contingency, and often settle or drop. What it does is it shifts power into your favor. So compared to domestic asset protection trust, limited by the full faith and credit clause, longer lookbacks, judicial familiarity, offshore transcends via sovereignty because U.S. courts don't have jurisdiction over our foreign trustee law firm like they would a U.S. trustee. Now for the promised stories. These are anonymized but drawn from real outcomes. Story one, a surgeon client faced a $10 million malpractice suit exceeding insurance. He set up a Cook Islands trust years before transferring investments. When judgment came, plaintiff tried enforcement offshore. Cook Islands court dismissed. Statute expired. Fraud unproven. Assets intact. Story number two, a real estate developer in a messy divorce. Ex-spouse eyed half of his portfolio, but properties in trusts, LLCs, U.S. court ordered repatriation of the funds. The trustee refused. No jurisdiction there. Settlement favored him, preserving 80% 1%. Story number 3, a tech entrepreneur hit with IP theft claims. Creditors froze U.S. accounts, but offshore holdings remained accessible. He weathered the storm. In fact, in the famous Anderson case, revisited in recent discussions, the Cook Islands stood firm against U.S. pressure, forcing a favorable settlement. So these aren't outliers. In my 34 years, offshore setups save fortunes where LLCs often fold. So if you're ready to act, here's your roadmap. Step number 1, assess risk. High net worth, litigious field like medicine or real estate, offshore is essential. Step number 2, consult experts. At assetprotectionplanners.com, we offer tailored plans. So mention this video for a complimentary review. Step number 3, secure wisely. So start with the Cook Islands Trust and LLC combo. Transfer assets ethically before threats. Avoid fraudulent conveyance. Step number 4, maintain compliance. So report to the IRS via Form 3520, 3520A, straightforward. Step number 5, layer your defenses. Use LLCs domestically for operations, offshore for core wealth. So don't wait, because being proactive is what wins the game here. Here's a pro tip: timing is the key. So plan when calm and not crisis. So there you have it, why LLCs fall short and how offshore, especially Cook Islands Trusts and Belize Trusts, deliver unbreakable shields. So if this resonated, subscribe if you haven't, like and comment. So what's your biggest asset protection fear? For personalized guidance, you can feel free to head over to assetprotectionplanners.com. So protect your legacy today, because tomorrow might just be too late. So thanks for watching. This is the Business Guy.